Sometimes the most profound battles begin with the smallest pills. In medicine cabinets across America, tiny white tablets sit quietly behind amber bottles, each one carrying the weight of deeply personal decisions made in moments of uncertainty and fear. For millions, these pills represent choice, autonomy, the right to determine their own future. For others, they symbolize something far more troubling, reflecting debates over values and long-standing beliefs. What happens when a single medication becomes the lightning rod for an entire nation's moral divide? When 23 years of scientific approval collides with ideological conviction so fierce it reshapes the very foundations of federal authority? The answer lies not in the chemistry of the drug itself, but in the human stories that surround it. The desperate patients seeking care, the doctors sworn to heal, the lawyers determined to fight, and the judges tasked with deciding who gets to choose. This is the story of how one pill became the center of a legal earthquake that would test the limits of scientific expertise, judicial power, and the meaning of justice itself. Because sometimes the most dangerous precedent isn't the one you see coming. A small white pill, no bigger than a baby aspirin, would trigger the most unprecedented judicial overreach in modern FDA history. One medication, approved for over 2 decades, used safely by millions, would become the catalyst for a Supreme Court case that threatened to unravel the very foundation of federal drug regulation. This is the untold story of how a shadow organization, a single judge in Texas, and a pharmaceutical controversy changed everything we thought we knew about scientific authority in America. This dramatized narrative is inspired by real legal principles and public case records. It is presented for educational and entertainment purposes, with interpretations attributed to their respective sources. The year 2000 marked a quiet revolution in American medicine. After years of rigorous testing, clinical trials, and scientific review, the Food and Drug Administration approved a medication that would fundamentally change reproductive health care. Mifepristone, marketed under the brand name Mifeprex, entered the American pharmaceutical landscape not with fanfare, but with the careful, methodical precision that defines federal drug approval. The numbers told a story of unprecedented safety. Over the following 2 decades, more than 5 million people would use this medication as part of a carefully designed medical protocol. The statistics were remarkable in their consistency. A success rate of 99.6%, a major complication rate of just 0.4%, a mortality rate of less than 0.001%, making it statistically safer than many common medical procedures, including childbirth itself. In hospitals and clinics across the country, doctors began incorporating mifepristone into their practice with the same confidence they placed in any FDA-approved medication. The agency's approval came with strict safeguards. Initially, only physicians could prescribe the drug, and patients were required to make 3 separate in-person visits. These weren't arbitrary restrictions, they were the measured response of regulators who understood both the medication's potential and the political sensitivity surrounding its use. But medicine, like all sciences, evolves. As real-world data accumulated, as studies multiplied, as evidence mounted, the FDA began what it does with all medications, adjusting restrictions based on scientific evidence rather than political pressure. In 2016, after 16 years of safety data, the agency updated its regulations. The evidence showed that healthcare providers beyond physicians, nurse practitioners, and physician assistants could safely prescribe mifepristone. The data demonstrated that the medication could be used safely up to 10 weeks of pregnancy rather than 7. The requirement for 3 visits was reduced to 1. Each change reflected not political expedience but scientific rigor. The COVID-19 pandemic accelerated what the data had already suggested. In 2021, facing unprecedented strain on the healthcare system, the FDA allowed mifepristone to be prescribed via telehealth and dispensed through certified mail-order pharmacies. The decision wasn't made in isolation. It was based on years of evidence showing that the medication could be used safely without constant in-person oversight. By 2023, medication abortion had become the most common method of pregnancy termination in the United States, accounting for more than half of all procedures. The reasons weren't mysterious. It was private, it was effective, and it was safe. For millions of Americans, mifepristone represented not just a medical option, but a fundamental aspect of reproductive autonomy. Yet in the quiet corridors of power, forces were gathering that would challenge not just this single medication, but the entire framework of federal drug regulation. The question wasn't whether mifepristone was safe. The scientific consensus was clear. The question was whether science itself would remain the final arbiter of medical policy in America, June 24, 2022. The Supreme Court's decision in Dobbs v. Jackson Women's Health Organization sent shockwaves across the American legal landscape. In overturning Roe v. Wade, the court had eliminated the federal constitutional right to abortion, returning the issue to individual states. But for anti-abortion advocates, state-by-state battles weren't enough. They had identified a different target, one that could potentially eliminate access to abortion nationwide regardless of state law. Just 1 month after Dobbs, in the sweltering heat of an August day in Amarillo, Texas, an organization called the Alliance for Hippocratic Medicine filed its Articles of Incorporation. The timing wasn't coincidental. The location wasn't accidental. The organization's strategy was breathtakingly audacious in its simplicity. If they couldn't ban abortion directly, they would attack the tools used to provide it. The Alliance for Hippocratic Medicine was unlike any plaintiff organization in recent legal history. It had no physical address in Texas, no local membership, no demonstrated connection to the Amarillo community where it incorporated. Its member organizations, 5 anti-abortion medical associations, were scattered across the country. The Catholic Medical Association, the Coptic Medical Association of North America, the American College of Pediatricians, the Christian Medical and Dental Associations, and the American Association of Pro-Life Obstetricians and Gynecologists. Their reported annual income was listed as $50,000 or less. Their digital footprint was virtually non-existent before 2021. Yet somehow, this shadow organization would launch a legal challenge that would ultimately reach the highest court in the land. Behind the alliance stood a more familiar name in conservative legal circles. The Alliance Defending Freedom, the same Christian right law firm that had successfully argued the Dobbs case, was providing the legal firepower. Their strategy was elegant in its cynicism. Rather than challenge abortion rights directly, which would require navigating the complex patchwork of state laws post-Dobbs, they would attack the federal agency responsible for drug safety. The plan was audacious. They would argue that the FDA's approval of mifepristone, maintained for over 2 decades, was fundamentally flawed. They would claim that every subsequent regulatory change, each one based on accumulating scientific evidence, was legally invalid. They would ask a federal court to do something that had never been done in American history: unilaterally remove an FDA-approved drug from the market against the agency's scientific judgment. But perhaps most remarkably, they had chosen their battlefield with surgical precision. The Northern District of Texas, Amarillo Division, was presided over by a single judge. Matthew Kaczmarek, a Trump appointee with deep ties to the anti-abortion movement, was the only federal judge hearing cases in that division. By incorporating in Amarillo and filing their lawsuit there, the Alliance for Hippocratic Medicine had virtually guaranteed that their case would land before a judge whose ideological sympathies aligned with their cause. This wasn't justice. It was forum shopping elevated to an art form. Judge Kaczmarek's background read like a roadmap of conservative legal activism. Before joining the bench, he had worked for the First Liberty Institute, a religious liberty law firm. He had written extensively about abortion, describing it in language that echoed the most partisan rhetoric of the anti-abortion movement. His judicial philosophy prioritized personal moral conviction over scientific consensus, raising questions among legal observers about impartiality. When the Alliance's lawsuit landed on his desk in November 2022, the outcome seemed predetermined. The question wasn't whether he would rule in their favor, but how far he would be willing to go in reinterpreting regulatory authority to achieve their goals. The lawsuit itself was a masterpiece of legal sophistry. It argued that the FDA had rushed mifepristone's approval in 2000 under political pressure from the Clinton administration. It claimed that subsequent regulatory changes were made not based on scientific evidence, but on ideological bias. It suggested that the agency had ignored safety signals and endangered women's health in pursuit of a pro-abortion agenda. Every claim was demonstrably false, contradicted by decades of scientific literature and regulatory documentation. But truth, as the alliance understood, was less important than narrative. And in Judge Kaczmarek's courtroom, they had found a venue where their narrative would receive the most sympathetic possible hearing. The stage was set for a confrontation that would test not just the future of reproductive health care, but the fundamental relationship between scientific expertise and judicial authority in American democracy. At stake was more than access to a single medication. At stake was the question of whether federal agencies staffed by scientists and medical experts would retain the authority to regulate drugs based on evidence, or whether individual judges armed with ideological conviction could override decades of scientific consensus with the stroke of a pen. The battle for mifepristone was about to begin, and the reverberations would shake the foundations of federal regulatory authority itself. The courthouse in Amarillo stood against the Texas sky like a monument to certainty. Inside its walls, however, certainty was about to become a casualty of ideology masquerading as jurisprudence. Judge Matthew Kaczmarek's courtroom was a study in contrasts. On one side sat the Alliance for Hippocratic Medicine, their legal team polished and confident, backed by the considerable resources of Alliance Defending Freedom. On the other side, attorneys for the FDA, seasoned government lawyers who had defended federal agencies for decades but had never faced a challenge quite like this one. The government's position was straightforward. They would argue that federal courts lacked the authority to second-guess scientific determinations made by expert agencies. They would present evidence showing mifepristone's remarkable safety record. They would demonstrate that every regulatory change had been based on accumulating scientific data, not political pressure. The Alliance's strategy was more complex. Unable to challenge the overwhelming scientific consensus on mifepristone's safety, they would instead attack the process by which that consensus had been reached. They would argue that the FDA had violated its own procedures, that it had ignored safety signals, that it had prioritized politics over public health. But beneath these legal arguments lay a deeper philosophical question. In a democracy, who gets to decide what constitutes acceptable risk? Scientists armed with data and expertise? Judges wielding the power of judicial review? Or ideologically motivated organizations claiming to speak for moral authority? As you listen, notice how easily this could be anyone's life. The first witnesses called by the Alliance were doctors affiliated with their member organizations one by one. They testified about their concerns regarding mifepristone. They spoke of complications they had treated, emergency room visits they had handled, patients who had required additional medical intervention. Their testimony was carefully choreographed, designed to create the impression of widespread medical concern about the drug's safety. But under cross-examination, a different picture emerged. Most of these doctors had treated only a handful of mifepristone-related complications over their entire careers. None could point to systematic safety problems that would justify removing the drug from the market. The FDA's witnesses painted a starkly different picture. Dr. Patrizia Cavazzoni, the agency's director of the Center for Drug Evaluation and Research, testified about the rigorous process by which mifepristone had been approved and subsequently regulated. She explained how the agency's decisions were based not on political considerations but on careful analysis of clinical data, adverse event reports, and post-market surveillance. The numbers were stark. Between 2000 and 2017, the FDA had identified approximately 4,200 adverse events associated with mifepristone among the 3.2 million women who had used the drug. 20 deaths had been reported during that period, with no confirmed causal link established, a mortality rate far lower than that associated with childbirth itself. But Judge Kaczmarek seemed unimpressed by the statistical evidence. His questions from the bench revealed a deep skepticism toward the FDA's scientific determinations. He pressed government attorneys on why the agency had relaxed restrictions on mifepristone while maintaining them for other drugs. He questioned whether the agency had given sufficient weight to moral and ethical concerns in its regulatory decisions. The hearing revealed something unprecedented in federal drug regulation. For the first time in modern history, a federal judge was seriously considering whether courts should substitute their judgment for that of scientific experts on matters of drug safety and efficacy. The Alliance's legal theory was breathtaking in its implications. They argued that the FDA had no authority to approve mifepristone because abortion was not a disease that required medical treatment. They claimed that every regulatory change since 2000 was therefore invalid, built on a fundamentally flawed legal foundation. It was an argument that would have surprised the thousands of women who had used mifepristone to manage miscarriages, to treat ectopic pregnancies, and to address related clinical situations. But nuance had no place in the Alliance's narrative. They had reduced the complex reality of reproductive health care to a simple ideological framework. April 7, 2023. The date would be remembered as a watershed moment in American regulatory law, though not for the reasons Judge Kaczmarek intended. His 67-page opinion read less like a judicial decision than a political manifesto. The language was inflammatory, designed to appeal to anti-abortion activists rather than legal scholars. He referred to abortion providers as abortionists, described mifepristone as causing women to kill their unborn children, and characterized the FDA's regulatory process as corrupted by political pressure. The ruling was unprecedented in American legal history. Never before had a federal judge unilaterally removed an FDA-approved drug from the market against the agency's scientific judgment. The decision didn't just affect mifepristone, it called into question the entire framework of federal drug regulation. Kaczmarek's logic was tortured, his reasoning selective. He cherry-picked data to support his predetermined conclusion while ignoring the overwhelming scientific consensus. He elevated anecdotal evidence over systematic studies, ideological conviction over empirical analysis. But perhaps most remarkably, he granted the Alliance's request for nationwide relief. A single judge in Texas, presiding over a case brought by an organization with no demonstrated connection to his jurisdiction, had presumed to make regulatory decisions affecting the entire country. The legal community reacted with shock and outrage. Former FDA officials, regardless of their political affiliations, condemned the decision as a dangerous overreach of judicial authority. Medical societies issued statements defending the scientific integrity of the drug approval process. But for the Alliance for Hippocratic Medicine, Kaczmarek's ruling represented complete victory. They had achieved something that decades of political advocacy had failed to accomplish. They had found a way to restrict access to abortion nationwide, regardless of state law, by attacking the tools used to provide reproductive health care. The Biden administration's response was swift and determined. Within hours of Kaczmarek's ruling, government attorneys had filed an appeal with the Fifth Circuit Court of Appeals, one of the most conservative appellate courts in the country. The stakes could not have been higher. If Kaczmarek's decision were allowed to stand, it would set a precedent that could fundamentally alter the relationship between federal agencies and the courts. Any ideologically motivated group could potentially challenge FDA approvals by forum shopping for sympathetic judges. The pharmaceutical industry watched with growing alarm. If courts could second-guess scientific determinations based on political considerations, the entire drug development process would become subject to judicial whims. Companies might hesitate to develop controversial medications knowing that their investments could be wiped out by ideological lawsuits. The marble steps of the Supreme Court had witnessed countless moments that redefined American law, but few cases had arrived carrying such profound implications for the relationship between scientific expertise and judicial authority. By the time FDA v. Alliance for Hippocratic Medicine reached the nation's highest court, the legal landscape had shifted dramatically. The Fifth Circuit had partially stayed Kaczmarek's ruling. allowing mifepristone to remain available while appeals proceeded. But significant damage to public confidence in regulatory science had already been done. The Supreme Court's chambers fell silent as Justice Brett Kavanaugh began reading the unanimous decision on June 13, 2024. 9 justices, spanning the ideological spectrum, had reached the same conclusion. The Alliance for Hippocratic Medicine lacked standing to bring their case. Standing. Such a simple legal concept, yet one that would unravel the Alliance's entire strategy. To have standing in federal court, a plaintiff must demonstrate concrete injury caused by the defendant's actions. The Alliance had argued that FDA's regulations forced their member doctors to treat complications from mifepristone use, creating a burden on their practices and consciences. But the court saw through this manufactured grievance. The Alliance's doctors were not required to prescribe mifepristone. They were not compelled to perform abortions. Their moral objections, however sincere, did not constitute the type of concrete injury required for federal jurisdiction. Justice Kavanaugh's opinion was measured but devastating to the Alliance's cause. Sincere legal, moral, ideological, and policy objections to elective abortion and to the FDA's relaxed regulation of an abortion drug alone do not establish a justiciable case or controversy in federal court. The ruling was unanimous. Conservative justices joined their liberal colleagues in rejecting the Alliance's standing theory. Even the court's most anti-abortion members understood that allowing ideological objections to substitute for concrete injury would open the floodgates to countless frivolous lawsuits. The Supreme Court's decision restored mifepristone's availability, but it could not undo the deeper damage the case had inflicted on American institutions. Judge Kaczmarek's ruling had exposed something troubling about the modern judicial system. A single judge, motivated by ideological conviction rather than legal precedent, had been willing to override decades of scientific consensus based on disputed interpretations of administrative procedure. That such a decision could be issued at all revealed vulnerable points in the relationship between law and scientific expertise. The Alliance for Hippocratic Medicine had lost their case, but they had succeeded in something else. They had demonstrated how forum shopping, shadow organizations, and ideologically motivated litigation could be used to challenge federal agencies. Their strategy would not be forgotten. Other groups pursuing different ideological goals would study their methods and adapt them for their own purposes. The precedent was not legal but tactical. A playbook for attempting to influence national policy through targeted litigation. As you listen, notice how easily this could be anyone's life. The pharmaceutical industry had watched the case with growing alarm. If courts could second-guess FDA approvals based on ideological objections, the entire drug development process would become subject to political or judicial uncertainty. Companies might hesitate to develop medications for controversial conditions, knowing that their scientific work could be challenged by activist lawsuits. The scientific community faced a more profound challenge. For decades, they had assumed that expertise would be respected by legal institutions, that evidence would triumph over ideology in matters of public health. The mifepristone case had shattered those assumptions, revealing how easily scientific consensus could be questioned when it conflicted with political beliefs. In the months following the Supreme Court's decision, a curious thing happened. The case that had dominated headlines for over a year began to fade from public memory. The dramatic confrontation between science and ideology, which had seemed so consequential at the time, was gradually overshadowed by other controversies, but the deeper implications lingered. The Alliance's lawsuit had revealed fault lines in American democracy that extended far beyond reproductive rights. It had shown how a small group of ideologically motivated actors could exploit the legal system to challenge federal institutions. The case also highlighted the fragility of scientific authority in an age of political polarization. The FDA's reputation, built over decades of careful drug regulation, had been damaged by a single judge's highly debated ruling. Even though the Supreme Court had ultimately reinforced the agency's authority, public trust in regulatory science had been shaken. Perhaps most troublingly, The case demonstrated how easily the pursuit of justice could become intertwined with ideological battles. The alliance had claimed to represent medical professionals concerned about patient safety, but their approach centered on legal strategies designed to reshape access to reproductive health care nationwide. Today, mifepristone remains available in the United States, prescribed through the same regulatory framework the FDA established based on scientific evidence. The Supreme Court's unanimous decision has been hailed as a victory for regulatory expertise over ideological activism. But the case's true legacy lies not in its outcome, but in what it revealed about the vulnerabilities of American institutions. It showed how quickly scientific consensus could be challenged by politically motivated litigation. It demonstrated how forum shopping could be used to circumvent democratic processes. It revealed how easily the language of legal standing could be manipulated to serve ideological goals. The Alliance for Hippocratic Medicine disbanded quietly after their defeat, but their strategy lives on. Other organizations pursuing different political objectives have studied their methods and adapted them for their own purposes. The tactic of creating purpose-built plaintiff groups to challenge federal agencies has become a standard tool of political litigation. In the end, FDA's Alliance for Hippocratic Medicine was never really about a single medication. It was about power, about who gets to make decisions that affect millions of lives, and about the role of expertise in democratic governance. The small white pill that started this legal earthquake continues to sit quietly in medicine cabinets across America. Each tablet represents not just a medical option, but a reminder of how fragile the institutions that protect scientific integrity can be when confronted with highly organized ideological efforts. The case taught us that justice, like medicine, requires careful dosing. Too little, and harmful actors go unchecked. Too much, and the cure becomes worse than the disease. Finding that balance remains one of democracy's greatest challenges. Sometimes the most important battles are fought not over what we can see, but over who gets to decide what we're allowed to know. And in that shadow space between knowledge and belief, between expertise and ideology, the future of scientific authority in America continues to hang in the balance. This is how a single pill shook the Supreme Court, not through its chemistry, but through the human stories that surrounded it. Stories of patients seeking care, doctors providing treatment, lawyers pursuing justice, and judges wrestling with the weight of their decisions. The verdict may have been unanimous, but the questions it raised about science, law, and democracy remain as complex as ever. Because in the end, the most dangerous precedent isn't always the one that gets set in courtrooms. Sometimes it's the one that gets whispered in the shadows, waiting for its moment to emerge.